they found it to be illegal for this guy in these circumstances, this one time.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
If you were to read some of these headlines this week, you might think that a Pennsylvania court has made making a gun-like gesture with your hand a crime. This comes from WPXI and from the Associated Press. Pennsylvania court making a gun-like hand gesture is a crime. Well, let's see if that's true, because it might not be true. Maybe there's just sensationalist headlines trying to clickbait for your attention so that you'll click and get advertisements like, "Are you buying, selling, or renting? Peruse a wide range of listings and properties in the Lehigh Valley. Visit LehighValleyLive.com." So that's what they want. They want you to come to their website and see that advertisement, and that gets them a penny or something. And so if 1,000 people do that, they get $10, and they can go home and make their boat payment. But what is really happening is that Stephen Kirchner was appealing a judgment of a sentence of a summary offense of disorderly conduct. He had made the hand gesture in the form of a gun, and he contends that he should not have been convicted for disorderly conduct for making said hand gesture. He didn't have the requisite mens rea, which means criminal intent, or his conduct was simply de minimis. So if that was all that it was, I don't think that it would be right for the court to affirm here. So let's continue, because I'm telling you, there's more to this. In June of 2018, Kirchner, the defendant, was issued a citation for disorderly conduct. It's a summary offense, which means you pay a fine. It's not really a misdemeanor or a felony. They don't take away your rights or send you to jail, more or less on the first offense. It's a fine. A trial was held. Lengthy facts were, or relevant facts were undisputed, and here are the facts. Josh Klingsian was mulching in his backyard when Kirchner and another neighbor walked through an alley that runs behind the yard to the neighbor's residence. Kirchner stopped, made eye contact with Klingsian, and then made a hand gesture at him, imitating the firing and recoiling of a gun. The incident was recorded by Klingsian, who had previously installed 6 security cameras at his home due to ongoing confrontations between him and the other neighbor, Natora. At the time of the incident, Natora had a no-contact order against Klingsian. Klingsian testified at trial that he felt extremely threatened when Kirchner made the gun gesture at him. Klingsian's neighbor, Yvonne Rodriguez, saw the incident from her front porch. She testified she saw Kirchner turn towards Klingsian and put his finger up like he was going to shoot him. Rodriguez stated she felt insecure after seeing the gesture and called 911. Kirchner testified in his own defense and admitted that he made the gesture. However, he said he did so after Klingsian gave him the finger with both hands. The court found Kirchner guilty and imposed a $100 fine and costs. Kirchner appealed, raising the issue: was the evidence sufficient to establish that making the hand gesture in the rough form of a gun creates a hazardous or physically offensive condition, and that the defendant had the necessary mens rea or criminal intent to sustain a conviction, or in the alternative, was the defendant's conduct de minimis, or so small that we don't need to do anything about it. The court will address the offense in 3 parts. A challenge to the sufficiency of the evidence requires us to determine, this is Pennsylvania state law, whether the evidence supports every element of the crime charged beyond a reasonable doubt. We do not assess the credibility of witnesses or the weight of evidence which are within the purview of the finder of fact, which would be the jury or judge at the lower court. As to the sufficiency of the evidence, our standard of review is brand new. Our scope is limited to a review of the record evidence, which means the evidence that has been put into the record, and they take the evidence in a light most favorable to the Commonwealth. So if there's a dispute or if there's a vagary in the evidence, it will favor the Commonwealth. Kirchner argues first that the evidence presented at trial was insufficient to sustain a conviction for disorderly conduct because the evidence did not establish that making a hand gesture in the form of a gun creates a hazardous or physically offensive condition. He argues that such a gesture is similar to actions that were found insufficient to support disorderly conduct convictions in other cases. He argues his actions no more support a conviction for disorderly conduct than any other hand gesture, as his hand could never be mistaken for an actual firearm. Kirchner was convicted under Pennsylvania state law, which provides that a person is guilty of disorderly conduct if, with intent to cause public inconvenience, annoyance, or alarm, or recklessly creates a risk thereof, the person creates a hazardous or physically offensive condition by an act which serves no legitimate purpose. The statute defines public as affecting or likely to affect persons in a place to which the public or a substantial group has access. Among the places included highways, transport facilities, schools, prisons, apartment houses, places of business, neighborhoods, or premises which are open to the public. Disorderly conduct is a summary offense, etc. It is not intended to be a catch-all for every act which annoys or disturbs people. Rather, the dangers and risks have to be assessed against the disorderly conduct statute. Specifically, a hazardous condition is a condition involving danger or risk. We conclude that there was sufficient evidence that Kirchner's act of mimicking his shooting Klingsian created a hazardous condition as it risked an altercation. Despite Natora's no-contact order against Klingsian and the ongoing rift between them, Kirchner, while accompanying Natora, approached Klingsian in his own backyard, created a gun-like hand gesture, pointed it at Klingsian, and made a recoil motion as if to suggest he had shot him. The act served no legitimate purpose and recklessly risked provoking a dangerous altercation. The cases Kirchner cite do not compel a different result. In Mertz and Forey, we determined that the remarks made by the defendants were insufficient to support convictions because the law applies when a person makes unreasonable noise. They are thus inapplicable to a handgun gesture with in a disorderly conduct case. In Maus, the defendant made insulting comments through the fence before retreating into his home. No one else present could hear the remarks, and the remarks could not have been heard beyond the two properties. We held that evidence insufficient. In contrast here, two other persons witnessed Kirchner making his hand gesture. In addition, given the history of the parties, as evidenced by the no-contact order against Klingsian and the 6 cameras Klingsian had in place, Kirchner's act risked an altercation or public disturbance. We thus conclude the evidence sufficient. On to the criminal intent. Kirchner argues that because his conduct was directed at a lone individual, he lacked intent to cause a public inconvenience, annoyance, or alarm. Kirchner's argument is meritless. We have specified that a reckless disregard of creating a risk of public inconvenience, annoyance, or alarm is sufficient, even if the defendant's intent was to send a message to certain individuals rather than to cause public inconvenience, annoyance, or alarm. Here, Kirchner acted with a reckless disregard of creating a risk of public alarm, as evidenced by the fact that an eyewitness on a neighboring property contacted 911 because his actions caused her to feel insecure. Another case, Kuhn, offers no relief. The defendant was charged with disorderly conduct as a third-degree misdemeanor. We concluded that a conviction under that subsection required proof that the defendant intended to cause substantial harm to the public or serious public inconvenience by his actions, and the evidence against the defendant did not satisfy that standard. Here, Kirchner was convicted of a disorderly conduct as a summary offense, which requires a lesser criminal intent of simply recklessness. The court goes on about the de minimis conduct, that Kirchner's final argument is that his conduct was de minimis. He cites the crimes code that when a violation was within a customary license or tolerance, neither expressly negative by the person whose interest was infringed nor inconsistent with the purpose of law, it did not actually cause or threaten harm or evil, and presents such other extenuations that cannot reasonably be regarded as envisaged by the General Assembly or other authority like the legislature. That is the legislature, the General Assembly. So they say this is all meritless. An offense alleged to be de minimis in nature should not be dismissed where either harm to the victim or society, in fact, occurs. In other words, the court does not abuse its discretion by refusing to dismiss charges where the conduct of the offender actually caused public alarm, annoyance, or inconvenience. Here, the trial court explained in its opinion that it did not find the conduct to be de minimis because it did in fact cause public alarm, annoyance, or inconvenience. In other words, the person called 911, they were alarmed. So a prothonotary is the clerk of court. So Pennsylvania still uses this, I guess, archaic word to describe the clerk of court. It is the proto-notary, the top notary, the most important notary. It is pronounced prothonotary, and they are the quintessential, they are the notary for the county. They are the clerk of court, the official witness and recorder of documents for the court for a county or municipal court or whatever. So that's the prothonotary, which is weird because normally the clerk of court would then record the judgment or record the opinion of this appeals court or whatever. Let's see, which appeals court is this? This is the Superior Court. This is the middle appellate court. We have a lower level court, the Common Pleas Court. We have a middle appeals court called the Superior Court, and then we have the Pennsylvania Supreme Court. And so this is a non-precedential opinion. Let's be clear on something. This is a it literally says this is a non-precedential opinion, Associated Press and WPXI. Non-precedential opinion means that this is not a case establishing that the handgun or gun hand gesture is illegal. So no, it does not mean that no one can go around making the gun hand gesture anymore. It means that you can't make that gesture in a context where it is alarming and incites public alarm. So if it causes your neighbor to call 911, okay, maybe I want to know a little bit more about why your neighbor would call 911 because you made a gun gesture with your hand. Well, if we look into it and it turns out that the reason your neighbor was alarmed is because you have a history of troubles with your neighbor, and so now your neighbor is wondering whether you're about to go get a gun and shoot them, or if someday they're going to unexpectedly get shot by you, that's legit. That's a legit concern. That's alarm. That's public inconvenience, alarm, etc. And so I think it's public inconvenience, annoyance, or alarm. So yeah, that could be disorderly conduct then in the totality of the circumstances, not just because you made a gesture with your hand. It's the gesture with your hand in connection with all the other things. So no, it is not even close to illegal to make the gun gesture with your hand alone. That is the media clickbaiting you, and it's stupid, and it should be that misrepresents the law. And now there are some people out there who want to go, those activist liberal judges trying to censor everybody. I can't even make a hand gesture anymore. Yes, I could understand how, upon reading these stupid clickbaity articles, including from the Associated Press, that you would think that that was the law. But it is not the law. And that is just a clickbaity article that completely misrepresents this Superior Court's non-precedential opinion. So let us know your thoughts about that in the comments. So the question is, do the articles portray it wrongly as well, or is it just the headlines? Looking at this article from the Associated Press, it says that a man was convicted for making the shooting gesture with his hand, and then the only details it gives is that he was walking past a neighbor's home and a witness called 911. Kirchner argued that it didn't create a hazardous or physically offensive condition, etc. So yes, it completely misrepresents the court's opinion. Same thing here. This initial above the fold part doesn't say anything about why it was considered, and then it says continue reading below, and there's nothing below. Maybe if I click this, that's it. The continues below is the one sentence. So yes, Those articles are absolutely misrepresenting that opinion, the fact that it's non-precedential, representing what the court even found, because the court did not find the gun hand gesture to be illegal. They found it to be illegal for this guy in these circumstances, this one time. If he does it again, yeah, it could still be illegal for him because he's still got a no contact order or he's still got a history with these people. But if this guy goes to the bar and he sees his buddy and he goes, "Hey buddy, how you doing?" with his guy, that's fine. That's his buddy. There's no history there's no history of misconduct there. So that's the difference. So definitely when you see headlines like that, you gotta read the actual court case these days because you can't even trust the Associated Press. I trusted the Associated Press pretty much up until this article. Now I realize that I can't even trust the Associated Press anymore. It's a sad world. So that is our show, everyone. Thank you for joining me for this Luxembourg edition of Lawful Masses. Thank you to all of our supporters. Remember, this is a community-supported legal education channel. We try to bring you daily and hopefully soon more than once daily videos about contemporary topics of law. We like to try and find the interesting things where we can explain something that the mainstream media or lay people will not necessarily understand, and without the benefit of a legal analysis. So we try to make this interesting for you, and with your support, we hope to take this to the next level within the next coming months. So thank you to Brandon, our editor, who is with us in the studio today, the virtual studio. Brandon is our community manager and soon to be our full-time editor. We want to pay him a living wage, so if you would like to help us pay him a living wage, please don't forget to support us on patreon.com/ljfrench or sponsus.com/law. You can also support us by subscribing to our channel, watching our content, clicking the bell, and choosing all notifications. YouTube is not sending our subscribers all notifications unless they do that, so gentle reminder to do that. Thank you very much to those who are supporting us financially in the month of September. Thank you to Joshua Davis of TandaPay. We are working on not just a TandaPay video, but also working on information about how you can either support or get on a list or get more information about TandaPay. Currently, we want you to go read the medium.com article that is in the description below of how or why Joshua Davis says TandaPay is going to work. And it is a really cool technology, and until we have all that put together, I'm not going to go further into a description. Once we have our messaging all unified, we'll make the video and have some unified messaging here on our channel. Thank you also to our $50 plus supporters, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Joe Tyson, and Blackleaf. Thank you very much for your support at the $50 level. And thank you to the $5 plus supporters who will be scrolling in front of me on the crawl at the end of the video. I'll ask Brandon to put some Luxembourg travel video. We have 1 million videos and pictures from our tour that we took of Luxembourg City yesterday. I have almost 200 video clips to put together, and Brandon will probably put some photographs in the outro here. Thank you for all of your support. Thank you for joining me today. I am Leonard French, your favorite copyright attorney. Thank you to Tactical Bra for joining us in the virtual studio as well. Love you all. Everyone have a great weekend and a great week. I'll see you in the videos that drop and in the comments below. Love you all. Bye.